Okay, I think everybody who's trying to join our meeting has joined, so let's go ahead and get started. Today is May 2nd, 2023, and it's just after 1:30 p.m. This is the Administrative Hearings Office of the State Water Resources Control Board's proceeding on the court's reference to the State Water Board in City of Marina versus RMC Lonestar, Monterey County Superior Court, case number 20 CV 001387. My name is Alan Lilly. I'm the Senior Hearing Officer in the State Water Board's Administrative Hearings Office. And with me from my staff today, joining us are Nicole Mullen, Kyle Woldridge, Skylar Anderson, and Regina Graziano. And as always, I greatly appreciate the help they provide to me in these proceedings. So with that, let's go ahead and just quickly have the appearances. If one attorney for each party can state his or her name, and then the names of the other attorneys and the witnesses who are here for that party. So let's start with California American Water Company, which I refer to as CalAm.
Good afternoon, Mr. Lilly. This is Michael Betts, Robert Moore, Mr. Robert Donlin, and Kathy Horning, appearing on behalf of CalAm. Thank you for your time.
Okay, and then which witnesses? Looks like you have some CalAm witnesses as well. You want to just list those?
Sure. We have a Mr. Peter Leffler and Dr. Johnson Ye.
Okay, great. Thank you. All right, Marina Coast Water District.
Good afternoon, Mr. Lilly. Kyle Brochard. Also on the line is Chip Wilkins and Christina Berglund. And the experts on the line is Dr. Todd Kincaid and Ms. Vera Nelson.
Okay, thank you. And for City of Marina.
There we go. Good afternoon, Mr. Lilly. Skip Spalding, representing the City of Marina. I am joined today by my partner, Larissa Meisenheimer, and our expert witness, Dr. Mark Trudell, is also on the Zoom.
All right, thank you and good afternoon. And then for RMC Pacific Materials, I think Mr. Neudecker, that's the current party name, is that correct?
Correct, and it's just me for RMC.
Okay, thank you. Okay, I think that covers everybody. Is there anybody who is appearing this afternoon who I've missed? I don't think so. All right. Well, first of all, thank you all very much for preparing your joint status report yesterday and submitting that, and for appearing this afternoon. I'm going to start out by saying I don't know whether it's my fault, but I'll apologize anyway. I know that the scheduling challenges are great here. And frankly, I was trying to avoid this situation back in January when I set up this schedule, because I know how hard it is for this many people to coordinate calendars, and particularly when we get into the summer where people have vacations, and for many of you, obviously, other proceedings that you're working on. But we're where we are, and we've got to figure out how to move forward. And as you know, currently my time at the State Water Board ends at the end of July. And right now that's a pretty hard deadline. So we'll have to discuss how we can go forward. Now, having said that, of course, the Administrative Hearings Office will continue. Mr. Woldridge and Ms. Graziano will continue and have considerable experience and expertise in this topic area and in this proceeding. And my supervisor, Nicole Mullen, the presiding hearing officer, certainly is eminently qualified to take over for the hearing officer duties for this proceeding. So the proceeding will go forward, even if I do not continue to be involved with it. So the first order of business I would like to talk about this afternoon is, what is the status of the Mr. Durbin's work? That seemed to be our hang up last time, or the, I say, area of uncertainty. So can somebody report to me where Mr. Durbin is with his work?
I'll take an initial stab, although he is unfortunately not here today, and perhaps Mr. Leffler can expand on this if necessary, but we
Okay,
understand that we made a commitment to deliver some materials yesterday, and my understanding is that was done. And period.
some materials is intriguing, Mr. Betts. So maybe it's better for Mr. Leffler to describe what those are.
Yeah, so basically from the regional model, the calibrated model run, was the materials provided yesterday. And so those are the materials that the local models needed to input boundary conditions and so forth, so that they can continue moving forward with their models. And if, Ms. Dr. Ye can elaborate further if needed, but I think that's the gist of it, the calibrated model run files from the regional model.
Okay, so that sounds very good. But I just want to make sure I understand this. So either Mr. Leffler or Dr. Ye, if you want to elaborate, does this mean you all have everything you need? And I will shift over to the MCWD and City Marina witnesses to answer this question as well, but I have to start somewhere. So Mr. Leffler or Dr. Ye, can one of you answer the question? Do you now have everything you need from Mr. Durbin to run your, what I'm calling, local model?
Yes, Mr. Didi. So we got the regional model input and the output file. Also the hydraulic conductivity distribution model, simulate the water level and observe the water level for the target wells. In addition to that, we got the water levels for the 4 major aquifers for the local model general head boundary, and streambed population within the local model. So with that information, we are able to proceed our local model calibration. That's also the optional A1.
Okay, so I'm sorry, I'm writing down, so bear with me. So did Mr. Durbin run the regional model in addition for what I call the baseline or without project and without Sigma implementation scenario? I assume that, Dr. Ye, I assume that's the A1 scenario. Is that correct?
No, that will be like A2, A3, B1, B2, B3. That will be predicted model scenarios. So I think he did some initial model runs, but right now he's going to use this calibrated model to conduct all that remaining model scenarios.
Okay, so he still needs to run what you call the predictive model scenario.
Yes, yeah.
Okay, and I don't know if any of the three of you, do any of you have any time frame for when Mr. Durbin is likely to complete that?
He's on vacation right now. He will be back next Monday, and he expects to complete that by May 11th.
Okay, so he's coming back May 8th, complete by May
Yes.
11th. That's by May, I'm sorry, did you say May 10?
May 11th.
By May 11th, okay. Nice having computers. That's impressive he can do that fast, but I guess once the model's calibrated, that goes faster.
Yes,
So then he would have the output files for those scenarios available to the others on May 11th. Is that correct?
yes.
Okay. All right. Well, that's very helpful. Thank you for the update. So I'm going to shift over to MCWD's technical experts now, either Dr. Kincaid or Ms. Nelson. Can one of you comment on what you've received from Mr. Durbin and whether it's adequate for you now to start the calibration process for the new version of your local model?
Yes, sir. I'll speak up for us. As Dr. Ye pointed out, we received files last night, and then there were some transmission problems, so we got all of the files that Mr. Durbin intended to send by about early mid-morning today. I have no reason to believe that there's anything wrong or that there's anything missing, but we haven't had enough time to verify, particularly the boundary heads. There's been some discussion amongst our team about what the boundary heads would be and how they will compare to the real world data. So that's like kind of just I don't have any reason to believe that they won't work just exactly as Dr. Ye said, but in the sense of disclosure, we haven't been able to verify that yet.
That's completely understandable. But I appreciate your explanation. So, and while I'm on you, Dr. Kincaid, I know when we talked last week in the status conference, there was some question about, I'll just say, the interface between the regional model, which I wrote down as a texture model, and then the local models, which actually model with model layers instead. And I don't know if you can answer this yet, since you haven't really had a chance to get into the regional model output files, but do you see any issue with that transfer between the texture model output and the local model, layered model inputs?
Well, sir, yes, I do see issue because they're two different conceptualizations of the world. So it is a concern, as I've said before. We talked about it. I believe we identified a path forward. But that is, like I said, that is the concern that I have, is focused on on the applicability of those boundary heads. And when we spoke last as a group, we shared multiple different interpretations of what those boundary heads are likely to look like. So there's at least two different interpolations directly from data out there. One was done by EKI's team, and the other is done by the county, I believe. We looked at different county interpretations, and then we also looked at preliminary or previous interpretations from the regional model and saw that they're quite a bit different. So I don't think there is a right answer. The goal is to make the answer consistent. And so I believe Mr. Durbin, well, I know Mr. Durbin said he would take layers from both Dr. Ye and I and compare them and use his best judgment to deliver heads to us. So like I said, I don't have any reason to believe that they're not going to work, but it is not straightforward, I would say. And so there is still, in my mind, there's still some concern about that. So we'll be taking a look at that and seeing if there's any problem with it. But barring some kind of latent problem, which I don't have any reason to think that there will be, but I think we should be good. But it is a complicated issue. These are two different interpretations of the world.
Well, I'll say I appreciate both your optimism and your caution.
Yeah, I'm trying to walk that line.
No, and that's good. And I know I know, I've always gotten the impression that you and Dr. Ye and Mr. Durbin, and of course the other technical experts, have been very constructive in trying to reach consensus where you can. And of course, then you're going to go in different directions from there. So thank you. One other question for you, Dr. Kincaid, before I move forward with schedule issues is, if you can work out these issues you've just talked about between the output files and if I'm clumsy about my terminology here, bear with me, but basically converting the texture model output files to input files for the layered models. Assuming you can get all through that and your optimism prevails over your caution, are there going to be additional issues when you receive what Dr. Ye referred to as the predictive model scenario output files from Mr. Durbin, or once you get through this initial step, will those then be fairly readily input into your local model?
I anticipate that they will be readily, we would be able to readily input them. So whatever potential problems we have with the transition, once we work that out for the calibrated version of the model, the rest should just fall into place. And we will have to repeat the import process and the assignment process, because as we've discussed before, there will be 12 different sets of files that are transferred from Mr. Durbin to the local models. But if there is a problem, we'll identify that with this calibrated scenario and rectify it, and then the rest should be straightforward.
Okay. And I appreciate straightforward doesn't mean click done. It's a little
No, it'll be a little more than that, but hopefully it won't
mildly.
be any problems.
Okay, and while we're on this topic, I haven't heard this before, but there's and I like the term predictive model scenarios that Dr. Ye, I'll just stick with that term. There may be other ways to describe it, that I think we all know what he was talking about. Does Mr. Durbin have the assumptions for the two, what I'm going to call potential sigma implementation scenarios? The way we set this up was CalAm was going to develop one potential sigma implementation scenario, and MCWD and City Marina were going to develop another one. So does he have the assumptions he needs to run his regional model with those two different scenarios?
So I don't want to speak for Dr. Ye. I believe that Mr. Durbin has them, but I'll let Dr. Ye answer for his scenario C for their sigma compliance scenario. But for ours, he has what he needs in terms of, we've identified what the goal is in terms of the head, the objectives, the head objectives on the eastern boundary. But he and Miss Nelson are collaborating, or were collaborating before he left for vacation, to identify how to design that. So the problem with our scenario is that there's many ways to skin a cat, so to speak. So the idea is that we asked him to say, okay, the heads on the eastern boundary, or the heads at these compliance areas, should be X in order to meet the sigma objective. But he can get there by just cutting all the pumping by a uniform amount, by cutting it in different areas by different amounts. And so in our last conversation with Mr. Durbin, I believe, and maybe Ms. Nelson can clarify if I'm misspeaking, but I believe the agreement was that she and Mr. Durbin were going to work together to identify two, let's call it schemes, or two methods or approaches to achieve the desired boundary heads, in terms of what pumping geographically is going to get cut and by how much. Of course, the exact cut will be determined through Mr. Durbin's modeling, but again, there's multiple ways to achieve that.
Okay, and just my editorial comment is, I do think it's important for the State Water Board, which obviously has to approve the its final report, and the court, the judge who has to take the report and decide what to do with it, to have some understanding of what types of pumping reductions we're talking about. Because, you know, clearly, I think clearly, they would have to be very, very significant to achieve these head goals. So that's why I want to make sure that at least at that level, the regional model, the description of the regional model scenario shows that. So before, Mr. Brochard, before I turn to you, Ms. Nelson, you were mentioned here in Dr. Kincaid's comments. Is there, and I won't say correct, but is there anything you want to, because I suspect Dr. Kincaid was saying it accurately, but is there anything you want to add in the way of clarifications to what he just described about the process that you are working on with Mr. Durbin?
Yes, and I think he described quite well that I think at this point, we're actually looking at two possible scenarios with regard to trying, you know, to estimate what the reductions in pumping might be, or equivalently, it could also be through additional water. In other words, you can either cut pumping or you can add water. The two are sort of synonymous, right? And so what we are looking at are two scenarios, one which basically would optimize the idea that you would cut as little pumping as possible or provide as little water as possible. And that's really done by limiting the extractions near the coast. It's not really linear. What you find with these problems is that if you are successful in cutting pumping really aggressively near the coast, the overall reduction in pumping ends up being much, much less. And then
I would just say that intuitively makes sense, but please go ahead.
And so the idea would be then, you know, either you would, you know, figure out a way to do that or provide water to those entities, and that would then limit the overall reduction in extraction required. And the other scenario that we had asked him to run was basically an adjudication scenario, which would basically be that if basically the east side subbasin and the 180-foot aquifer subbasin were adjudicated, it's highly likely that what would happen is, you know, based on, you know, senior water rights, there would be an equal cut in extractions. And so we would tell the state board, if let's say this area were adjudicated, this is the overall cut in the basin. But if people were actually smart and managed to do, you know, something other than an adjudication, you could actually get the reduction in pumping down to much less.
Okay.
So it'll give you those two things.
Thank you. That is very helpful. You've piqued my curiosity, and I'm going to ask this now. I don't really want to get too bogged down into this, but why would it just be adjudications of the east side and 180-foot aquifer subbasins? Why wouldn't you also need to adjudicate the forebay subbasin?
Well, you probably would if ultimately the basins were adjudicated. My guess is all of them would end up, you know, it would go through the whole valley. But these current scenarios with which Mr. Durbin has run have only looked at reducing pumping in the 180-400 and the east side subbasins. So the 50% cut that was identified previously was only in the 180-400 and the east side subbasin, which only is about 50% makes up only about 15 to 18% of a reduction in overall extractions within the Salinas Valley Basin. And the reason he did that is it's the same scenario where those are the basins that are closest to the ocean. And so you don't get any bang for your buck in stopping extraction up in the forebay. In other words, that doesn't really help the seawater intrusion. I mean, it does a little bit, but at the end of the day, it's highly unlikely that you would ever do it that way. You could redistribute the water through an adjudication, et cetera. But from the standpoint of meeting Sigma requirements, the only basins that would require cutback are the 180 and the east side subbasin.
Okay, thank you for that clarification. That is starting to sound familiar. I worked on this 20 or 25 years ago, so it's been a while, but thank you. That's starting to make sense. Okay, Mr. Brochard, you had your electronic hand up. Is there something you'd like to say right now?
Sure. I just wanted to note that these scenarios are completely hypothetical, and it's not. You'd said that the state board and you thought the court would want to look to see what this would look like. We have no idea what this is going to look like. Those will be additional studies. Those will be different models for different purposes. We don't know what Sigma compliance is going to look like, other than, as Dr. Kincaid said, what the minimum thresholds will be, what the heads need to be. We don't know what the public agencies will ultimately do to get there. So to put any weight into what those scenarios look like, I don't think that that's appropriate, which is also why we've said that we don't think that this is necessarily appropriate, but I just want to make the point.
Well, I certainly understand that we don't know what is going to happen. I mean, frankly, we don't know if the legislature is going to amend Sigma. And as Ms. Nelson has pointed out, I like that term, the smart way to do it, which of course means collectively all the decision makers in the basin are smart together, which is a challenge, even if they're all individually very smart. So I like the concept that she has described of sort of two bookends for how that could be done. But I've said it before, and I'll say it again. I agree with you. We don't know exactly how Sigma is going to be implemented or if it's going to be implemented. But I still think having some handle on what this means is better than simply saying, we're going to fix the eastern head, the heads at the eastern boundary of the local model, and just sort of magically assume that magically that is what Sigma will occur. So I very much appreciate what Ms. Nelson is describing about how she and Mr. Durbin are trying to give some meaning, some boundary or bookends to what that could mean. But with the caveat you just mentioned, and of course, in your filings in terms of the proposed report text and your briefing, I'm sure you will point that out, and you should. So that's fine. But I hope that's clear, that I just want to say I appreciate what Ms. Nelson is describing, what she and Mr. Durbin are doing. I think that makes a lot of sense here. So with that, Mr. Betts, your electronic hand is up. Go ahead.
Sure. Just a quick observation. I know we're here to have a healthy conversation about scheduling today, and it slipped sometimes into experts dialogue. We're not taking any testimony today. I just want to make sure that that's the agenda and that's clear.
Yeah.
Because it seems to slip into that.
This is not testimony. This is brainstorming to try to develop a constructive and efficient schedule. Yeah, I think all of the experts are at least that my impression is they're all approaching it with that goal. So yes, this isn't going to be things that we start having findings of fact. We're not even preparing findings of fact, but it's not things that the statements in the draft report are likely to be referring to. Of course, I think the technical experts will end up describing a lot of things in their testimony, and then we can cite to that, but not to what they say today. So I hope that allays whatever concerns you had about that. Okay, well, thank you. I guess I'm just going to circle through to Mr. or Dr. Trudell. Is there anything you want to add here to this discussion before I move on to talk about scheduling?
No, I really have nothing to add on these topics.
Okay, thank you. So I guess I'll say there's good news and bad news here from what I'm hearing. The good news is clearly a lot of progress is being made, and particularly with Mr. Durbin's work, which is sort of foundational to all the other modeling work that's happening in this phase. And that's good. There seem to be some uncertainties, and it may make sense to have another status conference toward the end of next week just to see where we are. So let me tell you what my thoughts are. And if you want, we can have a break and you can caucus internally before you react, because you may want to develop consensus reactions. But let's see. So I said last time that I wanted to have the hearing at one of the last 2 weeks in June, which of course became the last week in June, so that there would be time for you all to, number one, to complete the hearing then, and then time for you to prepare your text for the second half of the draft report and any related arguments in closing briefs. And then the goal was to get that filed toward the end of July, so I would at least have some time to review that before I leave. After I read your statements yesterday, I realize you all are proceeding in good faith and are trying to meet that schedule. You had the deadline for exchange of the summary slides wasn't quite a week before the hearing started, which I was a little concerned about, because that's where my colleagues and I really would be spending some time trying to develop our questions. And I know it was Mr. Osias's suggestion before, but which I think was a good one, that we may be able to ask questions and kind of let you all know what don't understand or trying to learn more about. And that may limit a lot of the need for cross-examination. I mean, as I've said before, I think cross-examination in a process like this is a very difficult way to get out information. I mean, clearly, each witness just saying, I disagree with the other side's witness, and here's why, is going to be far more effective than some lawyer trying to extract some concession out of a witness who doesn't agree with what the lawyer is trying to get the witness to say, which is sort of how cross-examination often goes. I think there may be some useful limited cross-examination. This is something I know the lawyers will all cringe, because it's totally contrary to all the training we ever get about cross-examination. But I'll tell you, in my experience with water board hearings, a lot of times clarifying questions, asking witnesses to explain what they did or what some point of their testimony is really productive and is often the best cross-examination, even though that's contrary to what they all teach us about how to do cross-examination. So anyway, those are my thoughts going forward. I think if we have time to prepare our questions first, then cross-examination may be limited and the hearing may be able to go a lot faster. So now, having said that, I did read in your statement some ongoing concern that this is going to be a crunch to get everything done. And I can certainly see that. If Mr. Durbin gets the scenario output files toward the end of next week, which is May 11th, then exchange of if you have exchange of the scenario files for June 1st, maybe that's still doable. I don't know. And then we'd have the hearing at the end of June. So I just want to throw out, I could consider changing the hearing dates to the third week in July. That's the only week in July that I'm potentially available. That would be July 17th through 21st. Doesn't necessarily have to be all 5 days, but we probably want to reserve at least 3. I prefer to reserve 5 and only use 3. And then, of course, move the filing deadlines that's 3 weeks later. So we would move the filing deadlines roughly 3 weeks later. I would like to get a little more time in there between when the slides are due and when the hearing starts. So I would, and then of course your closing briefs and proposed text would be filed sometime in August. And right now, my plan is I would not be reviewing that. I certainly would give comments on the trial court's issues after the hearing and would pass those on to Mr. Woldridge, Ms. Graziano, and Ms. Kunze for their consideration, but then it would be hard for me to be involved after that. And they would be preparing the draft report, but so that's sort of a disadvantage. Although frankly, I don't know how much time I'm going to have to work on it anyway, if you file things toward the end of July. And of course, the advantage is it gives your experts more time to prepare and organize your testimony and rebuttal and the slides and to prepare for the hearing. So I want to throw that out for consideration. Looks like Mr. Wilkins' electronic hand went up now. So I'll ask him, and then I'm going to propose we take a break so you can discuss internally whether or not you think that, because it's not really fair for me to put you on the spot, and different attorneys for the same party may have different views. So Mr. Wilkins, do you have a comment or a question?
I do, and it largely deals with what you just addressed. And as we said in our moving our proposal, this is very much less than ideal. This June hearing, Dr. Kincaid will be testifying the entire time in Scotland, so he'll be testifying basically in the middle of the night. But we are willing to do this.
He's young. I'm sorry. Go ahead.
Yeah, that's true. He's willing to do it, and we've discussed this, and we have to have. We'll compensate Miss Nelson for moving a family vacation. These are all difficult things, but the reason that we would agree to do it is we believe it is of critical importance that whoever conducts these hearings is the person who writes the decision. And we don't understand how a judge who didn't preside over the hearing, didn't hear the testimony, could write a decision and assess credibility of witnesses, et cetera. And we think you're obviously in the ideal position to do that because you've heard all the prior testimony. You don't have to come up to speed. And so it made sense to us to crunch everything. And we still think there's not any room there's no cushion in the schedule, in our opinion. If something goes wrong, it's going to get blown up, and we just don't control that. But we will do everything in our power, and that means people working late nights and moving vacations to make this happen. But the reason that we believe it's worth doing is because we are under the impression that you will write the decision. And that's why we had an earlier date for exchanging closing briefs than Cal-Am did, was we moved that up slightly. But if you're not going to write the decision, I believe it's our collective thought, and we can convene on this, but I would like to get your comments on whether you will be writing a decision, that it doesn't make sense for us to kill ourselves if you're not even going to write the decision. That's what we discussed amongst ourselves. And it's largely to do with the knowledge factor that you have, because we've spent a lot of time bringing, where you've heard all these experts. I know you have excellent staff, but staff should not be writing this opinion. And certainly, I'm sure we'll be assisting you. But we expected that you, as the presiding judge in this case, would be the one writing a decision. And we think it's very odd that a judge who didn't hear a case would then come in and write a decision. And so we would like clarity on that before we convene on whether you will be writing a decision if we do this hearing at the end of June.
Okay, well, it's a fair question. And first of all, again, I'm sympathetic to the fact that we all have real lives and try to live them and not just work all the time. And that certainly involves vacations and so forth, which are critically important. And I mean, as I said before, this is why I really wanted to get this all done in May, because I just know how summers go. And, of course, we all have those things we want to do, and that's important. And the problem is we all have them scheduled for different times. So I apologize for that. That's sort of the mess that we're in. But to answer your question, Mr. Wilkins, first of all, a couple of comments. First of all, the way this is going to be set up for this round of hearings, which I think really will be the critical round. I won't say it's going to be everything for what goes into our report, but it'll be most of it because we've really refined from the prior hearing rounds we've refined where there's consensus, and I think can identify the areas of disagreement and hopefully isolate the differences in model results that come from those areas of disagreement. So I think it'll be mainly from this hearing round. And frankly, the way we at the Water Board do hearings, it'll be primarily from the written proposed testimony. We have direct and rebuttal. It's going to be all written. So anybody can read it as well as I can. But, I'm not downplaying what you're saying. There certainly is some value to having what I've done to go through the other rounds of hearing and get familiar with all the details. But to answer your question, if we have the hearing in the end of June, and then the parties submit their closing briefs and proposed text for the other report sections on either July 21st or July 24th, it's not realistic to think we're going to have a draft proposed report by July 31st. I mean, there's just too much technical detail for that. So what I would do is, of course, review what has been filed and prepare some kind of an internal deliberative process memorandum to Ms. Kinsey, and basically to pass it on to her to work with Mr. Wooldridge and Ms. Graziano to finish the draft report. And the way whoever does the draft report, we're going to get 2 versions of text for each section of the report, and we do have a detailed outline, and we're going to review those and most likely prepare a 3rd version that's some combination of the other 2 versions. It's possible for some sections we'll go, wow, they've really got it all exactly right. We'll just accept one party's text for that section, but obviously most likely there'll be some give and take between the 2 versions. And, that's our job, and we want to do that well. So I'm sorry if I'm rambling a little bit, Mr. Wilkins, because you're asking a very important question, and I'm trying to give you the best answer I can. And the answer is, even if we have the hearings in the end of June, I will provide some input, but the bulk of the report writing is going to have to go on after I have retired from the State Water Board. There's some possibility. I'm not committing to this. I don't even know if it'll work. There's some possibility I could review a draft down the road after the end of July and provide some input. But I just from a personal point of view, I have to significantly limit my time after that, because it really is time for me to move on with another phase of my life. So I hope that does that sort of answer your question? I'm not sure you like the answer, but does that at least answer your question, Mr. Wilkins?
With the exception of the slight glimmer of possibility that you added there at the end, it answers the question, but it raises very serious concerns on our side, as we've said, for multiple reasons, and we'll have to convene and figure that out. Ms. Meisenheimer may have further comments. Like I said, we thought very seriously about this and talked about it and put our statement in. But let me convene with my co-counsel, but Ms. Meisenheimer might want to get some clarification at this point.
Yeah, I didn't ask you whether you liked the answer. I just asked you whether you understood it or not. So thanks. And I think you're saying you understand it and you don't like it. So that's fine. I get that. So Ms. Meisenheimer, your electronic hand is up. Go ahead.
Thank you. One of the things that we're trying to navigate is, and we've been so focused on getting to the hearing, but there's also all of the stuff that comes after it. And so we're going to have to report back to the court in this matter about how much time before there's a final State Water Board report, when the trial can be. And so I was hoping that, you know, with some emphasis on sort of where you'd be involved and where not, what happens after, so we file our final briefs, let's say they go in, you know, July 21, what happens from there and what are the timelines?
Okay, it's a good question, but it's not quite as hard to answer as predicting Sigma implementation over the next several decades, but it is a little challenging. I'm being facetious here. The answer is we will, as I said before, we will take the text, and we already are working on the first part of the report. That's why I wanted to get the text in, which I appreciate you're all submitting last month. And we already are working on that part of the draft report to try to get this process going forward. So we will take the text that we will receive from both parties on the other outline sections. Of course, we'll read the closing briefs. I'm hoping the closing briefs can be fairly short and basically just say, if at all, if necessary at all, here's why we say this in our proposed text. Here are the legal authorities that we think support that. Obviously, some of the legal authorities can be in the proposed text anyway. But we will take that and we will review it. And then, as I said, we will meld, is probably the best word, the two drafts section by section. I'm hoping we won't have to change the outline. Frankly, I don't think we will, because the court has given us pretty clear questions to answer, and obviously we will follow those. So we will work on that. But that's, I mean, just based on my experience, that's a 30 to 60 day, potentially even more, depending on largely on what other work staff has. That's a process that's going to take some time. And then when that's done, we will have a draft referees report, which we prepare, the AHO prepares, with Ms. Graziano's input from ORPP. And then we circulate that to the parties, and there's a water code section that says we must give at least 30 days for, and of course you'll want 30 days for review and comments, review by and comments by the parties on that draft report. And then we will prepare, the AHO, will prepare a proposed final report. And we will transmit that to the clerk of the board and set it on the board's meeting agenda. And of course, we can brief and will brief internally the board members. We can either brief them when we send out the draft report or the proposed final. Probably we would start with the draft report just to get them up to speed, because this is pretty complicated. And they're very good, technically very proficient board members, but obviously they have a lot to work on. It takes a little while to get up to speed. So then so the draft report is circulated to the parties have 30 days to submit comments. And then we prepare a final proposed report, which realistically is roughly another 30 days, and get that on the board's agenda. And then this would not be a decision or order, but my understanding, my prediction is the board would have a proposed resolution that they would consider adopting, which, if they adopted, would approve the report and direct staff to transmit that to the court. So those are the steps in the process, largely set out by the water code and just board process. So does that answer your question on that?
Yes, thank you.
You may not like that answer either, I don't know, but that's just sort of the framework we have to operate in. Okay, so you can go ahead and put your hand down, your electronic hand down. Got it. Okay. So does anybody else have any questions or comments for right now? This is sort of a lot. What I'd like to do is have all of you have the opportunity to confer internally and then report back to me on thoughts. I mean, basically, I think where we are is, I think we have a pretty clear calendar. I would like to have a status conference on May, say 12 or 15, just to get a report on where Mr. Durbin is and hopefully get a positive report on this question of interfacing the output files from the regional model with the input files in the local model. And his report on running the other predictive scenarios. So I want to do that in any event, but then the real question is, do we follow the proposed schedules? And both of you were pretty close on the first round of proposed schedules for the June hearing. And then Marina Coast had a much longer schedule, assuming we had a hearing later on, which I say I don't think is realistic. But we potentially could have that hearing 3 weeks later in July and make corresponding changes in the pre-hearing schedule. So with that, I'm going to propose we take a break until 3 o'clock and then come back then. But Mr. Wilkins, your hand went up and back down. Did you want to ask?
I guess obviously it would be helpful to know why you don't think a August hearing date is realistic or reasonable before we even articulate our rationale for why we believe that would.
Okay, and the reason, it's a good question, and the reason is when I talked with Ms. Kinsey, she said, correctly so, I think, she really wanted me to run the next round of the hearing, just because that has to be done by a hearing officer, and she and I are the only ones in the AHO right now. And that would be very difficult for her to get up to speed to run a hearing. She's much more comfortable taking the hearing record and then working with our staff to prepare the proposed report. But she did not want to run the hearing. I am scheduled to be not working for the State Water Board after the end of July. So that's why I wanted to have the hearing in July and not August. So I hope, does that make sense? Again, you don't have to like it, but you at least understand what I'm saying.
I understand your position or the water board's position.
Yeah. And I'm just saying I started on this proceeding about 1.5 years ago. I had no idea it was going to take this long. But I do think we are making a lot of good progress with the consensus, and I'm glad we've gone to that effort. I mean, otherwise, we were going to be sort of stuck with just accepting one side's model or the other, and they both of you had good points as to the critiques of the other side, so we didn't want to do that. And I think we're going to end up with a much better product, but that's why it's taken this time, and that's why we're now in this crunch. So let's go ahead and take a break. So Mr. Anderson, is it best can people sign off and then log back on so they don't run the risk of having their candid conversations heard on this, or do they have to go on hold and come back at 3 o'clock? Or Mr. Woldridge, if one of you can tell me. Go ahead, Mr. Woldridge.
I'm not sure how it's going to work with the Read AI, but I think everybody can log off except for AHO staff, or you can log off as well. And that should work fine. We'll keep the meeting going.
Okay, so I think that's easier for all of you. I don't want any of you to accidentally have your internal discussions broadcast to our proceedings. So you can all log off. Let's everybody log back on just before 3 p.m. and we'll come back and I will ask for reports from you as to what your thoughts are on how to go forward. And if necessary, we can schedule another status conference, but I'm hoping with 35 minutes, you can reach some consensus internally for each side. You don't have to talk to the other side, but internally for your proposals, and we can go forward. So let's leave. AHO staff will keep the meeting going, and we will come back at 3 p.m. Thank you. Try again. Nicole, can you hear me okay?
Yes, I can.
Okay, I think it's now 3 o'clock. Let's go ahead and let everybody in and get started. Okay, it's 3 o'clock and it looks like everybody is back, everybody who was on this call earlier this afternoon. So let's go ahead and get started. I'm not going to repeat the introductions. I'll assume the recording will still have that. So we had a break. I had some ideas. I wanted to get reports back from the attorneys on basically potential schedule conflicts and concepts and ideas for how much time the witnesses need to prepare their exhibits and proposed written testimony. So I don't know, who would like to start on the report back to begin with? Does anybody want to start? Mr. Wilkins, your electronic hand is up. Why don't you go ahead? Thank you.
So for Marina Coast and I believe the city of Marina, we believe that there are a number of scheduling conflicts for us in July that would be difficult, if not impossible to move, including the fact that I will be in Salzburg. And I don't know if my wife would like me to spend my evenings in a hearing for her 60th birthday, but that's a separate issue. We think we should push forward with the June dates at this point, but hold the July 20th date for now. And at the status conference you suggested, I think on the 15th or 11th, I'm confusing it in my head right now with other dates, that we should revisit this and make sure we all still believe the June 26th date works. Assuming that we do hold the hearings in June, I think we can work through the differences in the dates. We're amenable to getting that closing brief to you potentially sooner if it helps you and means you can be more involved in a decision. If we end up going with the July date, due to a trial that Mr. Brochard is in for basically most of the end of July and the beginning of and through middle of August, we don't think it's realistic for us to get you a trial brief in August. It might have to be September. So, but at this point, if we're working with the June dates, we think we can make the schedule work. It requires, as I said, a lot of accommodations, including Dr. Kincaid, who will be calling in from Scotland. But that is our preference at this point. But we don't want to vacate the July 20th possibility. But it does present a large number of challenges for us. You're on mute, Mr. Lilly. Still can't.
Thank you. When you said July 20, do you mean July 17 through 21?
Sorry, I apologize. Yes.
Okay. All right. Anything else from either of the city of Marina attorneys on this?
No, nothing further. Thanks.
Okay, so what does Cal-Am have to say about this?
Not to break stride, but we're somewhat in consensus. We all put together a lot of time and effort to come up with a schedule. So we would like to proceed with the June dates that we have both mutually proposed. We all have scheduling issues. I can tell you our witnesses have weddings and vacations and all those. I'm not going to go into those with you, but we have a state court judge that really wants to get this done. We have a coastal commission that wants to get it done. We have a governor that wants to get it done. We have people needing water that really want to get this project done. So we'd like to proceed forthwith and stick with the schedule we proposed. We believe we should be scheduling for success, not for failure. And if something does come up, we could address it then. On a side note, given some of the scheduling issues you've identified, Mr. Lilly, we also think perhaps to the extent it's possible, getting Ms. Kenzie involved as soon as possible would be helpful. I note that you're gone for a little while. I believe you said, maybe I made a mistake, towards the end of June, or this month or next. And if things do come up, having someone we could go to, we've often been reaching out to the State Water Board, to which this matter has been referred. And in terms of the closing briefs, similarly, we think we should stick with the dates we proposed for no other reason than after the hearings, it does take time for the court reporters to come up with final transcripts, and those may be very important. So we will need some time to at least get those transcripts finalized. So in sum, we stand by the dates that we proposed. Having said that, if you really felt that July was necessary, we will make that work as well.
Okay, well, thank you. You threw out a lot of different concepts there, but I appreciate your getting all the information across. I just so you know, I did talk with Miss Kinsey during the break, and she is eavesdropping through YouTube on this, so she is up to speed with this proceeding. I'm not sure what her reaction is going to be about having her be available to issue rulings while I'm out. And just so you know, my current schedule is to be out of the country from June 1 through the 11th. So just for basically a week and a half in there. But I'm hoping there won't be any things on which rulings are necessary while I'm gone. Okay, so other than, well, other than Mr. Wilkins, I think I heard your schedule conflict for July 17th through 21 is that entire week. Is that correct?
Yeah, well, July 17th, I'm actually in Europe for 3 weeks there, starting July 17th through August 4th, I believe it is. And, you know, could I make any accommodations? I can't move the trip, but I potentially can try and figure something out. I know we also have Dr. Trudell, who is unavailable on the 17th and 18th, I believe. But again, he's, if we end up going with that date, he said he can look into potentially making some schedule adjustments also. So there are a number of conflicts, and we will have to deal with them as we can. Some people, my unavailability doesn't mean this can't go forward. It means potentially, but experts is a bigger problem.
Yeah, I mean, of course, we want all the attorneys we can who want to participate to be able to, but there is some redundancy with the attorneys. I mean, frankly, each party has several very qualified attorneys in this proceeding. So I'm not as concerned if one of them can't participate as long as some other attorney can cover for that, the missing attorney. I mean, you've all demonstrated very high competence and understanding in this matter. But the experts are a different story. They're not really fungible. Each have a specific area of expertise, and they're all important. Okay, well, that's helpful. One other thing I wanted to ask, which has been touched on with some of these. It's anybody else? I assume Mr. Newdecker, do you want to add anything?
No, we'll make whatever works. We'll make it work, whatever works for everybody else.
Okay, thank you. Didn't want to forget you. So one other thing that I talked about with my staff during the break is, and I think Mr. Betts, you may have alluded to this. If we're going to go with the June hearing dates, and you want me to try to provide as much input as I can, obviously it really would help me to get the draft report text and the closing briefs on file as soon after the hearing as possible. And I know that's a bit of a crunch, but on the other hand, frankly, I've given you notice before, and a lot of this you can be working on ahead of time, particularly when the hearing is going to be very largely just authenticating written proposed testimony and exhibits. I mean, this is not a typical trial where there's a lot of new information. I think most of the information will be in the written proposed testimony before the hearing even starts. So having said that, does anybody have any comments on, I mean, you're currently proposing that the closing briefs, I think one side said July 21st and the other side said July 28th. Is there any comment on if we tried to crunch that time up a little bit?
Yeah, I'm sorry, on behalf of CalAm, yes. I mean, we put a lot of time, Mr. Lilly, as you know, into the front stage of these proceedings and briefs and the like, and using your words and not agreeing or disagreeing that this next phase is important to you. We are not going to get a lot of the written testimony until shortly before the hearing, or the summary slides, which I believe you also indicated are important. So for us to digest that and properly brief an issue, which is really, really important, I think even the times we proposed were a bit aggressive. So we would really maintain that the dates that we propose should be the dates. We don't want to just throw something together. As I said, this is all coming to the end, and you've expressed a lot of importance on what's happening in the end. So time to brief this at the end is really of utmost importance to us. So we respectfully maintain the dates that we proposed. Quite frankly, we would like more time.
Okay.
But jamming it does not make sense for anybody, given how much time we put onto this.
Well, and I certainly don't want schedules to be so short that the quality of work product goes down. Doesn't do me any good either. So, Mr. Wilkins, your electronic hand went up. Do you want to say something about this?
Sure. I speak for Marina. The city may have a different position because we didn't discuss this, but I think we said we could agree. We can get an expedited transcript from these hearings quickly within days, if usually the next day. And so we don't believe the transcripts are a problem. We know what issues we have to brief already. We've at least ourselves started working on those briefs. And so in order to allow you to have more time with them, I believe we could agree to shorten it to July 14th, shave a week off. So we have 2 weeks after this is all said and done. But I would defer to the city to make sure they think that's realistic also, or my co-counsel, because we didn't actually talk about an alternative date with openly. That wasn't under consideration during our meeting. But I do think it's possible to take some time off that.
Okay,
Yeah, I agree with
just
Mr.
wait just a minute. Well, go ahead, Mr. Spalding.
Right. I agree with Mr. Wilkins, and I was actually going to propose the 14th, so we're good with that.
Okay, well, clearly there's a different, you've all reached agreement on a lot of things, and here there's clearly a difference between what Mr. Betts is saying and what Mr. Wilkins and Mr. Spalding are saying. I do want to just emphasize, I mean, I've done a lot of these now, and I know most of you have not done as many of this type of hearing, but I'll just say it one more time. I really think most of your citations will be to the exhibits and the written proposed testimony and not to a reporter's transcript. I mean, the purpose of this next round of hearing is summaries of your written proposed testimony. And by this point, my staff and I are pretty up to speed on, we know where the wells are, and we know where the layers are and so forth. And we know the basics of the modeling. So the summaries of the testimony will be pretty clear to us. We will probably have some clarifying questions, but the only things that are really going to happen orally during the hearing are those clarifying questions and perhaps some cross-examination, which, again, as I've said before, I think is going to be pretty limited. Clarifying questions, yes, but beyond that, I'm not sure it's going to be super productive to try to spend a lot of time getting witnesses to admit things that they're not going to admit.
Sure.
So anyway, Mr. Betts, go ahead. I think I may have struck a nerve with you, so go ahead.
We've been trying to be very accommodating, sticking with the rules from the beginning. I'm not going to relive all that. We were okay to go into July, but it's not as much as the transcripts. I get that, and I get that I brought it up, but this is an entirely new process, and we're going to have new summary slides, new written testimony within weeks or whatever it is before our new hearing date. To digest that all into these briefs is going to take significant amount of time. And if there's crunching to be done, crunching on the briefing is something that we really believe is not in the best interest of the outcome of this case. So I get it. I'm with you. I understand that there's going to be no gotcha on the cross-examination. We could get transcripts, but a lot of this new information, it's not even developed right now. We're still developing it on both sides. So to put that into, even if we didn't have a hearing, quite frankly, it's going to take time to put these briefs. And the end of June dates that we already agreed upon was already a big crunch just to try. And we were all just forcing ourselves to get that done just to meet with your schedule. So cutting it back even more, I just respectfully think that's going to make it hard for your office, for the State Water Board, for us. And we're just going to be slapping together product that we should not be doing. So I strongly urge that we have these briefs due at the end of June. It doesn't fix anything, doing it earlier.
Okay, I think you mean July, but I understand what you're saying.
July, yes.
Okay, so we will evaluate that, but I certainly understand where you're coming from. Fairly strong views on both sides, I will say, on this one issue. So the other question, which I probably should have started with, because it's really what comes first, are, do you think that the technical experts are going to be able to meet the deadlines that you have proposed in your schedule for them? And I'll just reiterate or repeat or state the first deadlines for submitting exchange of the regional and local model files, which MCWD and the city proposed May 15th and CalAm proposed May 19th, and then going forward for exchange of the model scenarios files, written proposed testimony, and then rebuttal, and then summary slides. I mean, we moved those from the original dates because the technical experts needed more time, particularly Mr. Durbin, to get his work done. But does anybody have any concerns about whether those dates are reasonable at this point? Mr. Wilkins, you're electronic. Well, you first. He beat you to it, Ms. Meisenheimer, so you get to go second.
I have a feeling
it's like Jeopardy or something, but I try to go by when the hands go up. Go ahead, Mr. Wilkins.
I have a feeling we're probably, we've discussed this with our experts, and they made it very clear to us that they believe they can make these dates, but there is certainly the possibility of technical issues coming up, and we are relying on Mr. Durbin to get us the information on the 11th in order to meet this schedule. We anticipate that he will be able to do so, and there won't be problems with it. But as you heard Dr. Kincaid say, we just don't know. And so is there concern? Absolutely. That's why we're suggesting we have at least this May 14th check-in, because we just don't know. And we don't want to overpromise and underdeliver. And our experts have made it clear to us that this is a very big push. There is almost no room for error here. It is going to require a lot of late nights. One of the reasons that they're willing to do June is they've set aside their schedules. They've turned other clients away and said that we're not available until such and such time, and moving the schedule around in a lot of ways doesn't help them. And so they're willing to do this crunch, but is there concern? Yes, is the answer to that, at least from our perspective of Marina Coast. And I'm guessing because we've discussed this with our experts together, Larissa, Ms. Meisenheimer probably has a similar concern, but I'll let her state whatever those are.
Anything to add, Ms. Meisenheimer?
No, I mean, I agree with Mr. Wilkins' sentiment. I think that, for very good reasons, there's a strong desire to get this to hearing and say we've got this on an ambitious schedule, that if everything goes right, we should be able to meet. But it, as we all know, modeling things happen. And so I concur that it is a very good idea to set a hearing, May 15th, May 16th, somewhere in that time frame to see where we are, so that we're not sort of crashing into deadlines that we're not ready for.
That's a scary metaphor. We don't want that. Okay.
Yeah.
All right. And just to be clear, I was looking at a status conference either May 12th or May 15th. That's a Friday or a Monday. So I don't know, of course, some of it depends on what the deadline is. I mean, CalAm's proposed that the exchange of the model files be on May 15th. I mean, Marina Coast has, Cal-Am's proposed May 19th. So do you think by May 12th is a week from this coming Friday? Is it better? I'll just ask. I can do it either. I can do it either at the afternoon on May 12th or anytime on May 15th. I think we should have another status conference just to see where we all are. I mean, this is the most efficient way for me to get all your input without having any ex parte communication. So I appreciate your bearing with me. At least you don't have to travel to Sacramento for these. So Mr. Betts, go ahead.
Sure, I'll answer your first question. Do we have concerns? Yes. In terms of a follow-up status conference, we'd urge May 15th, probably in the afternoon, because we'll be digesting what happens on the 11th.
Okay.
So I think
that makes sense.
15th in the afternoon at the earliest.
And I assume Mr. Wilkins or Ms. Meisenheimer, does that make sense to you as well?
Yeah, I mean, I
It does,
guess,
although I have a conflict that afternoon, with the morning of May 15th work, that would be better.
Mr. Wilkins, do you want to say something?
all I was gonna suggest is we may be able to file something with you before the 15th if everything's going well, say, everything's okay, we don't need the status conference, and you can say vacated. And I would also say that depending on if there are any issues, we may not need the experts, because as I said, they are in crunch mode. It could just be attorneys checking in if there's little changes needed to the schedule, but I would think that if the parties agree there's no need for the status conference because everything is going fine, then it could be vacated. I just think it should be there as a placeholder. That's my.
Yeah, that's fine. And that was actually the way we set up the one today, although it turned out we needed it. Okay, so Mr. Betts, are you okay with sometime in the morning on May 15th rather than the afternoon?
You know, we have some conflicts that yes, or alternatively, May 16th, anytime.
Okay, yeah, I think I'll do it maybe late morning on the 15th. Well, I don't know. I'd rather do it in the afternoon. Ms. Meisenheimer, is this something you can have Mr. Spalding take care of for you? I mean, it should be pretty short. It's sort of like either it's okay or it's not, so.
Sure, and if necessary, I can see if I can move what I currently have scheduled that afternoon.
I mean, I'm sorry that it's just, we have, different conflicts. So, okay, well, why don't we do it we'll do it at 11 a.m. on the 15th. I didn't hear anybody have a huge problem with that. So let's do that. And then between now and then, I'm going to confer with my staff as to what we think the proposed schedule should be. I'm getting a pretty clear message that everybody wants to keep the June 26th hearing date and develop a schedule based on that. I don't think anybody wanted to go to July unless necessary because of some unexpected development with the experts modeling work. So that was a clear message. So we will consider that in developing our schedule. So, okay, Mr. Wilkins, go ahead. Your hand went up.
I would like to prompt Dr. Kincaid here on the schedule for one issue only. It's our experts' belief that we need a minimum and would like longer in between the exchange of the calibrated model and when the scenarios and all of our direct testimony is due, because we have a fair amount to do during that time frame, including obviously put together the direct testimony, and we need to exchange calibrated models before we can do certain things. So I don't want to I just prompt Dr. Kincaid or Dr. Trudell, who are doing the work, to explain why we think we need at least 2 weeks between the calibrated model and the time frame for submitting the scenarios and direct testimony.
Okay, and I mean, you don't need to say anything more, Dr. Kincaid, unless you think you do. I get that, and it's not. I guess it's not surprising that MCWD wants more time than Cal-Am because it's getting things from Mr. Durbin. So, but potentially we could have that be May 16. Cal-Am would propose May 19, MCWD would propose May 15. So if we made that May 16, it would be after our status conference, and you'll know whether or not you're going to be able to meet that deadline And then the next round would be June 2nd. That's more than, that's that's like 2.5 weeks. I really.
That would be excellent.
Yeah. I mean, as I said, the one deadline I didn't like was the slides coming in on June 22nd. So we'll see. We may tweak these a day or two. We'll keep them pretty close. Okay. Well, again, I apologize for having to do this, but I'll say if we didn't do this, we'd be having a hearing in September or October. So we have to deal with everybody's schedules. I mean, I was worried about this last summer, and that's why we had the hearing set for October to avoid this mess. But unfortunately, we're now carrying over into another summer, but just the way it is. So, okay. Well, I will get out another proposed. I will get out another schedule, which will be our schedule unless changed. And we will definitely plan to meet on May 15 at 11 a.m. for another status conference. And of course, we'll send out a notice of that. And it sounds like it would be good for the attorneys again to submit a joint status report, which on May 12th, just so we have it ahead of time, which can either say everything's fine, we don't even think we really need a status conference, or here's where there are problems and areas of disagreements, here's what we would like to talk about on May 15th. And as always, I do appreciate the fact that you're willing to talk with one another and get consensus where you can and prepare joint documents. It really is quite helpful. All right, we're sort of beating this up for again today. Anything else anybody wants to talk about? All right, well, thank you all very much. And also thanks to the technical experts for your descriptions and input. I certainly appreciate that. And with that, I will work with my staff to get an order out in the next couple of days, and we will target to meet on May 15th at 11 a.m. Thank you all. Have a good day and work hard on that modeling work. Bye.
Thank you. Bye.